Hi, my name is Florence Paul, and this is Levelling With, the legal podcast with a difference. Over the coming weeks, I'll be bringing you some unique insights into the law, how it influences your life, how a legal perspective can enhance your business, and where legislation can help structure conversations concerning issues we face in society. In these first episodes, we'll be looking exclusively at the moments in your life where you'll need to consider engaging a legal professional and why.
What this means is that we have this hierarchy of relationships that's sanctioned by the government.
What should we be doing? What should the law do to protect cohabiting couples?
The question we need to ask ourselves as a society is, should we still be protecting this category of marriage over and above cohabitation?
In our first episode, I'll be joined by Francesca Skakel. Francesca is a family lawyer and is passionate about seeking reform on the rights of cohabitees. Currently, 1 in 5 couples are living together in a cohabiting relationship in England and Wales, the equivalent to 3.6 million couples, making cohabiting couples the fastest growing type of family. Often, it is found that people assume that they may have the same rights around property as married couples, but unless you've entered into a marriage or a civil partnership, you may not have the same protection. Can you start by telling us what the current law is surrounding cohabiting couples and what the differences are between a couple that's cohabiting and a couple that are married or in a civil partnership?
Yeah, so this is an area that's completely marred by its legal complexity. It's out of step with public opinion, and it doesn't really have a lot of clarity surrounding it. And the combined total of that essentially means that it's a nightmare for separating couples to have to navigate. And it's very difficult to give you, in accordance with married couples, a very clear summary of what the law is. Because for separating couples, depending on your precise situation, there's a variety of different statutes and laws that could or can apply. And it's difficult for me, a solicitor, to explain the totality of that, and even harder for lay people to navigate. So yeah, in terms of the difference primarily between a married couple and a cohabiting couple, married couples have a whole armory of laws aimed at correcting relationship-generated disadvantage and ensuring that when they come out of a relationship, their needs are met.
Sure.
And in 2001, we had this case, White and White, where they essentially aimed at correcting and making very clear that there should be no distinction between, a breadwinner and a homemaker. Compare that to cohabiting couples. What you have there is the law is very, very brutal. It's really just comprised of property law. So have you purchased a property whose name is on the title? And can you, in a very, very limited amount of circumstances, show a common intention to the contrary, which is different to the legal ownership? So have you contributed to the house in a significant way or such to change the property ownership, or why the position on the deeds at the land registry shouldn't reflect the true ownership of the property? That's very difficult to actually prove. And then you separately have protection for people with children, and that area of law is really limited to the Child Maintenance Service, which is a blunt government-aided tool and has all the difficulties and delays that come with government organisations. And then you have separately the Children Act, Schedule 1 under the Children Act, which offers, in very limited cases, financial protection for people with children. And it's really reserved to them. So to the wealthiest of people with children. And those awards under the Children Act are really, again, very limited compared to what you get under marriage. We don't have nearly the same amount of orders. And for the most part, they are only for the duration of the child's minority, with the interest returning to the paying parent at the end.
So would that be in terms of, say, a property whereby an unmarried couple have raised 3 children together, they separate during the children's minority? So what would happen in that situation?
Yes.
What could happen?
So again, it's a very difficult thing to actually involve the Schedule 1 court on the issue. For the most part, what happens in those situations is we look first to LATA, which is the property law statute, and then we separately say, well, does that create a situation of unfairness? And do the parties here have the money and capital to justify an application under Schedule 1? And I say that because Schedule 1 applications are very risky and they have high costs awarded to them. And what we have is a situation where barristers are trying to creatively shoehorn arrangements to meet parent with care and children's needs, because the law in and of itself under Schedule 1 of the Children Act is intended to be a very limited provision to just ensure that someone has their needs met for their minority. So in terms of maintenance, you wouldn't ask the court to deal with that under Schedule 1.
Even if the parent isn't working, so say the parent who is caring for that child, there wouldn't be maintenance covered under Schedule 1?
So maintenance is covered under the CMS, the Child Maintenance Service, for income below £156,000 gross. Anything above, you can make an application to the family courts, but recent case law, James and Seymour, suggests that we just really apply the CMS calculations for the most part up to quite a high level of income. So it's usually not worth the money to go to court if you're just looking at maintenance. The property point is a slightly different one, which is, does the non-resident parent have an excess of capital in order to afford for a child's minority housing for the parent with care. And then it returns back to that non-resident parent at the end of the child's minority. So it's very limited protection, and there isn't really much scope to provide for financial protection for the parent with care. So we commonly think about things like a carer's allowance, but it's really very limited compared to marriage. What this means is that we have this hierarchy of relationships that's sanctioned by the government. We have those who are deserving of protection and equality and equal recognition under marriage, and then those that do not nearly have the same level of protection and recognition, who are cohabitees. And it's ridiculous that we are still talking about this, and we're still recognizing this huge divergence of protection in 2024. I mean, in 1982, the Law Commission was trying to push through cohabitation reform. Right. Resolution, since its foundation, has 2, which is about 40 years.
What should we be doing? What should the law do to protect cohabiting couples?
Yeah, so this is where it becomes a slightly difficult thing, because we look at our neighbours to the north, so Scotland, and they have no time limit on the amount of time you have to be together, but they look at the factors of the relationship. Is it akin to a husband and wife situation or a civil partnership situation?
Is that to protect people that, say, have moved in 6 weeks ago, or, lived together for 6 weeks or something, to then have a claim against someone else's property? Or
Yeah. I mean, it's to try, not to the full extent of marriage, but to a better extent, to correct relationship-generated disadvantage from any cohabiting situation. So if you move in with someone and you're only there for 6 weeks, you may still have suffered a disadvantage if you've put money into the property, or if you've given up your job to look after the kids or such. It's really, that's a really admirable thing to do, and most laws should be trying to, 1, be in step with public opinion, but 2, correct fairness, and to correct for fairness and to assure equality, and fairness is being met. And it's difficult in terms of what should we do in England, because we have the opportunity here to start from scratch. And it's commonly mooted that if we have a cohabitation law, then we're going to have to define what is a cohabiting couple.
Yeah.
And this is where we run into what I like to call the Scotch egg problem, where we have to define what, a substantial meal is, but here what a cohabiting relationship is. And there's a whole category that is not protected under the current laws. So we're talking about, of course, cohabiting couples and people with young families. But we're also talking about religious marriages. So people who haven't had a civil marriage and just have had a religious marriage. Couples who reunite after divorce. Polyamorous relationships, asexual relations. And if we got to frame a law that encompasses that wide category of people, we have to be forward-looking. You know, we've got laws for marriage from 1973 and for children in the 1990s. These laws are in place for a long time, so we need to be forward-looking when we're coming up with these definitions of a cohabiting couple or just a cohabiting relationship, trying not to be too limited, and again, in scope and thinking of polyamorous relations.
Does that not then bring with it its own problems if you widen the definition too much? So including anybody that lives, I mean, I live with someone that I'm not in a relationship with, but what would my rights then be under a very broad definition of cohabiting couple?
Yeah, and this is a really common issue when we're thinking about how this law should come to be. How do you distinguish between an asexual relationship and roommates? I think what we'd have to do is consider relevant categories or factors that make it more of an enduring relationship, something familial, beyond something that's a bit more transactional or, as roommates often are, you're trying to reduce the rent together or
sure.
such. Just to broaden the category out. And
what kind of factors would you include in something like that?
Yeah,
shared finances, or
I think you'd probably have as many inclusive factors as possible. So you'd have things like sharing finances. You look at the length of the relationship. You'd look at whether or not it was a sexual relationship. You look more generally into whether there were children, and you look into just the extent of the interconnectedness between the parties. And I don't think we'd want to have it be, an inclusive category, so you have to tick every box, but just to leave it as open as possible. Now, the question then becomes, does that open the floodgates to litigation? And would we have the courts flooded with people wanting to, shoehorn themselves into that criteria? But I think, any good family lawyer will know that the majority of cases are settled, and very few cases end up in court. And there's very little reliance on the court to determine the financial settlement agreements in marriage, and similarly under Schedule 1 of the Children Act. So I would suspect that if we brought in law which is inclusive, it's a harm reduction technique to make sure that we're not excluding a category of people or relationship, but we're also ensuring that all these people can seek legal advice on their situation and have a lawyer advise them whether or not they're entitled to any kind of settlement to correct for relationship-generated disadvantage.
And do you think that the any reform that comes in should be on the same principle as marriage?
Yeah, so I guess the question we need to ask ourselves as a society is, should we still be protecting this category of marriage over and above cohabitation? And
we're applying that to civil partnership as well now.
Yes, sorry, I'm using the word marriage, but I mean marriage and civil partnership. So if we sit marriage and civil partnership on a pedestal, should we? Is question one, and question two is, if we do, what's the next step? What should the law be for cohabiting couples? In terms of whether or not we should protect for marriage, I think if we think of marriage as an opt-in system, you are knowingly entering into a certain stage of your relationship where you give vows, and there's a very clear acknowledgement of this being, hopefully for life. And it's a commitment, and I think everyone recognizes it as a big commitment. Switch to the perspective of a cohabitee, where you often find yourself in a situation where you have been living with someone for some time, but you haven't necessarily reached that stage of, yep, this is it for life. So there's probably, in terms of the consciousness of entering into that relationship, a different category in your expectation there. Should it be significantly less than the marriage protection? I think probably not. I think there needs to be this correcting for relationship-generated disadvantage. But should it go more than that? I'm not so sure. In marriage, the starting point is this more 50-50 split.
Yeah.
But I think to correct for relationship-generated disadvantage and to ensure that you're independent going forwards will assist most people. And again, it's that harm reduction of making sure that people are protected and have protection from the legal services versus the autonomy argument of, well, we've deliberately entered into this commitment, which is what you get with marriage.
And could you apply a similar system in that for divorcing couples, you have 5 years for a short, up to 5 years for a short marriage, medium marriage, long marriage? Could you apply a similar principle for cohabiting couples, do you think?
I think it can probably just be more simple than that, which is if you're in a relationship for a short amount of time, the disadvantage you suffer is probably less.
Yeah.
So again, I think a problem with the current law is we tend to shoehorn categories. And I think if we leave the law open, but guided by fairness criteria and guided by overarching principles around what are we trying to do with this, i.e. if we say we're trying to correct for relationship generated disadvantage, that's a very clear correction. It gives someone a very clear starting point, i.e. putting you back into the situation you were at the start, in as much as possible, ensuring you're independent going forwards.
So taking it back to advising individuals that might be thinking about moving in with a partner that, say, owns their property, what would your advice be? What kind of protection is there for somebody who doesn't want to get married, isn't willing to, or doesn't feel like they're at that stage yet?
Yeah, I mean, until the reform comes in, and we're very much hoping it will come in, it's very difficult. One, because there is this lack of awareness at present. I mean, 46% of people in England and Wales currently believe in the myth of common law marriage, and it's even higher for those with children.
And that's, sorry, just to define common law marriage myth, that's...
So that's this understanding that cohabiting couples have the same protections as married couples after usually a misconception around the amount of time they've been together. Given such a high percentage of people have this erroneous belief, where do they get their correct source of knowledge from? You would think conveyancers. That's the most obvious step when people enter into a key stage of commitment as a cohabiting couple. They go and buy
purchasing
somewhere.
a property.
Yeah. And then the second stage would be when they have children. Conveyancers don't really want to depress their clients. So we often find that they don't tend to mention, you realise you're not as protected as you would like to be if you were married. And similarly, midwives or hospitals, it just doesn't really come into the conversation, you know, understandably other priorities at present. So it's really difficult for people to know, one, that they need help. And you know that Netflix show, Marriage or Mortgage, and it's like, what should I put my £30,000 money towards, a deposit on the house or like amazing wedding?
Yeah.
Quite a lot of people scream at the TV like, it's so obvious, get a house, it's a better investment. But they don't know what they're giving up in terms of legal protection by not getting married. So it's really tough. I think we need to improve the information campaign at the conveyancing stage at least, to make sure that people are aware of their rights, or even have leaflets in maternity wards or IVF centres to make sure parents are aware of their rights. And then, you know, I think the second step is, once you're aware of it, what can you do about it? Really, a cohabitation agreement is a great place to start. It has all the protections of a contract. And it means that at the outset, you're having a clear expectation of what your rights are in respect to the property you're purchasing, or if you share a pet, what happens to, Fido when you split. And just having that simple conversation at the outset saves a lot of unhappiness if there is fallout. And, like getting a power of attorney or like getting an insurance contract, you put it in a drawer and you try and forget about it, and hopefully it will never be relevant, but at least you've got that protection.
Peace of mind, yeah. And is there a way that you can approach that conversation sensitively? Obviously, like you said about conveyancers, no one wants to put a downer on that situation. And obviously if you're moving in with a partner, it's an exciting time, but...
I think this is why it needs to come from the conveyancers, because at least a signpost for further legal advice. Because I think if there was less of a stigma around, whenever you purchase a property together, you're signposted to independent legal advice on whether or not you should think about the ownership and the underlying ownership and what happens if you separate. If that stigma was reduced because it was a conversation in every joint purchase or every purchase where there was someone else moving in, then that should be a very, it should become more and more common. Again, it's a little harder if someone's moving in later.
Yeah, it's a loophole where someone already owns the property and then you're moving in.
Yeah, it becomes a lot more difficult then. But I think if it was just a question that was raised at every conveyancing stage, then it would increase the awareness with the public that, if someone else owns the legal title, I might not have any rights.
Yeah. And you mentioned earlier about contributions towards that property, so be that paying some of the mortgage. How does it change if you move in with somebody who owns property, but then you start contributing to utilities, mortgage?
Yeah, again, it's very difficult to prove that because you're contributing to the mortgage or utilities, you're entitled to a share of the underlying ownership. And this is one of the problems, is that if someone's legal name is on the title, the presumption is that they own it, and the burden's on you, the other person, to prove that it should be different. And this is a huge lacuna, because people can pay thousands and thousands of pounds towards utilities, towards mortgage, and unless there is a conversation which is clearly recorded, where we sit down and say, yeah, you're entitled, you must pay 50% of the mortgage because this is our house, and regardless of what the legal title says, it's our property and we should equally share it. It's very hard to depart from that presumption.
And if the worst thing happens and you do separate and you are unprotected, is there anything you can then do? Obviously, you've just said about it's pretty hard to prove, but is there any protection post-separation?
Yeah, as a starting point, get legal advice. Speak to a property litigation specialist if you have lived in a property which is owned by someone else, or equally if you own it jointly but you think you should be entitled to a larger percentage for whatever reason. Seek legal advice. It's very, like I said, it's a very high bar to prove something other than the land registry, but not impossible. And if you have kids, that bar is a little lower. But it's not completely removed by any means. And the protections under Schedule 1 of the Children Act are really the reserve of the wealthy, have high risk associated with them. And in most cases where people leave with children, you're limited to child maintenance. There's a very famous case, Burns and Burns, which was, I think, the 80s, where after 24 years of being in a relationship, not married, several children, all grown up, she left that relationship, no job, and with just her washing machine, which was the only thing she purchased. We're no further on.
Wow. So if you had one message to cohabiting couples, one piece of advice that you'd give, what would it be?
I think as soon as possible in your relationship, try getting legal advice and try having those conversations with your partner around a cohabitation agreement, and putting in clear terms what your property will look like in the event that you separate. And that could be even just limited terms of how much notice can I have before I have to leave the house, and what do I do about payment of
practicalities that you wouldn't think about.
Practicalities that you don't want to be discussing when you're in the very emotional stage of separating, that you want to just have squared away right at the beginning when you're happy and able to have reasonable, calm conversations about these things. And just lump it up in the category of, insurance, power of attorney, wills, conversations that no one wants to have but are worth having, because when it's too late, it's too late.
So another thing that no one wants to talk about is obviously in the case of one of the partners dying. So what would happen if I was living in my partner's house and they died, but they own the property and I don't have any rights?
Yeah, I mean, as opposed to married couples where the presumption is if you have no will, it all goes to the other spouse. In the case of cohabiting relations, there is no such presumption that exists. So unless there is a specific will in place, there will be no protection or claims available to you on death. There, again, always worth seeking legal advice, but the circumstances on which you can make these claims are quite limited. and nowhere near this presumption that exists for married couples where there's this automatic claim. So I'm a member of Resolution, who are a group of family professionals who are striving to ensure better working relations and clearer and fairer laws in family. And Resolution 40 years ago were campaigning for an improvement to cohabitation laws and cohabitation law reform. And in November, they sent their Visions for Family Justice, which is aimed ahead of the upcoming general election to try and get on, as part of these discussions, cohabitation law reform as part of mandates. And I'm really hoping that as part of that review, we'll look into the unfairness created through the separation process and through death, and more generally look at reforming these laws, which have been in place for over 30 years, unchanged, and everyone ending up in a burns and burn situation, walking away after 25 years of a relationship with their washing machine. And, I'm really hoping that this will become a bigger conversation and that there will be serious review, because it's needed. We have bad law at present and reform is required.
And what's the situation with tax if someone... So obviously when you die, and if someone dies in a married couple, then there's tax breaks for inheritance. But with cohabitation...
Yeah, it is exactly the same. So, whether we're talking about capital gains tax, this presumption that if you're, transferring assets between spouses, then there will be no tax, or on death, transfer between spouses' estates is tax-free. None of that exists. So you're suffering a lot of financial hardship by virtue of not being married. And a common issue arises when, on separation, a cohabiting couple, one will purchase the other person's interest, and that leads to a stamp duty charge, whereas it doesn't for marriage. So that is another big example of how different the laws are and how different tax treatments are for cohabiting couples and married couples.
I just wanted to touch on the parenthood question again, in terms of if you are unmarried and you have a child. Obviously, the mother has automatic parental responsibility, but what is the situation for a father or second, same-sex parent?
Yeah, so unless you're explicitly named on the birth certificate, you do not have parental responsibility as a father or second female parent. If you're married, the presumption is that you are the father or second female parent for the child. And that's, again, it's just a difference in all these presumptions that exist. And it's funny, the Children Act, which Schedule 1 relates to, was actually a product of the Bastardly laws in the 90s. So, this is the type of archaic terminology which has led to the law as it navigates the system to date. It's archaic, it needs reform, it's creating a lot of unexpected and unknown gaps in the legislation that people are falling into. They're not opting in. They're not choosing not to get married because it's a principled decision. And if they are doing it, they're doing it unaware of the consequences for the very mass majority. So yeah, it needs reform.
Would you advise people to enter civil partnerships or marriages? Or, I guess you can't really...
Yeah, there's a clear answer for that if you are the person who is likely to suffer a relationship-generated disadvantage, which is, yes, you are better protected if you're married, and you're better protected if you're in a civil partnership, and you're better protected if you have children. But if you're the financially stronger party, it's an abusive system because it allows for the financially stronger party to assert their control over the relationship and to just prevent marriage and have the other party, the financially weaker party, fall into this lacuna and not receive adequate legal protection as a result. I think there's a philosophical reason why people who opt into a system get different protections to people who do not voluntarily opt into the system. So we have quite a protective legal system. We like to try and ensure that people's needs are met where possible and there's fairness equated to that. But we also respect this autonomy that people have, their decision to have certain protections or not have certain protections. And I think, I don't know, it's probably the case, to be honest, that there is a higher recognition of marriage, as there wasn't before with civil partnership, because we have a system that's probably based too much on religion. And the institution of marriage has this certain religious category protection, which is for some reason or other historically perceived as more meriting better protection, or meriting better protection. However, now I think the conversation's moved on, and we have this opt-in, opt-out system. But just because you're not opting in doesn't mean that you should suffer the disadvantages to the extent that you suffer them now, particularly where it's so out of step with public expectation and opinion. And we can't have a legal system which is not respected or understood by the public. And I think we've had that for the last 40 years. And it's beyond due to get it reformed.
Mm-hmm. And the disadvantage that we're talking about, is that because of things like somebody having to take on a larger share of the kind of homemaking role while somebody else is carrying out the breadwinner role?
Yeah, so commonly we do think of that. Stereotypically, the woman stays at home, looks after the kids, and loses out on earning protection. They lose out on earnings for a number of years, and they lose out on increasing their earnings in line with a man's, because they've had to take a break from work due to childbirth, and then there's a knock-on effect on pensions. It can be quite significant when you start totting up what the effect would be. And, commonly when you speak to financial advisors, which we often do as part of our job, it's quite shocking the impact of just taking a few years off work on your actual lifetime earnings and your pension. So it's really, and I say this to couples who are getting divorced, but generally it's always worth, if you are separated from a relationship, getting some financial advice, so you are aware of calculating that relationship generated disadvantage and ensuring that you can have that need met going forward, which you can do under marriage at present, but of course not yet under the current cohabitation laws, or property laws and financial provision for children laws. Mm-hmm. Interestingly, in Scotland, they don't provide pension sharing orders as part of their cohabitation rights.
Right, but they would under matrimonial.
But they do under matrimonial. So I'm not quite sure as to the rationale for that decision, save that it's just that lesser protection that they're recognising between marriage and cohabitation. I'm not sure if I would want to see that same issue in any law that England brings in. I think if we're striving to correct for disadvantage, we have to have the full spectrum of awards made under marriage, albeit that instead of the starting point being 50-50, the starting point would be to correct for disadvantage.
Okay. Amazing, thank you. Me again. Thanks for listening to this episode of Levelling With. Next week, I'll be chatting to Shibli Begum. Shibli will be talking us through the process of becoming a homeowner and how to avoid the most common mistakes made. Remember to rate us on your app of choice for podcasts. And if you like this episode, why not subscribe? We're available across Spotify, Apple Podcasts, and Google Play. Also, follow us on social media. We are at Burkitt's LLP on Instagram, LinkedIn, X, Facebook, and TikTok.